Shalom, this is Yah is Magnified, and I'm back with another informative video. Today's video is titled, Does the Fair Debt Collection Practices Act Apply to Child Support? But before I tackle this subject, as always, I must state for the record, I'm not a lawyer, I do not practice law, and I do not pretend to. All my videos are for informational and educational purposes only. They are all facts and all truth. Nothing more, nothing less. So with that being said, I would like for you all to hit that like button. And also, if you're new to my channel, hit that subscribe button. And also hit that notification bell so you all can be notified as I'm dropping these powerful videos. So without further ado, let's get to it. Okay, so now as you all can see on the screen, we are in fact coming from the Consumer Collection Handbook, okay? So for those who are looking for this information, simply search the Consumer Collection Handbook, okay? So now, as you all can see, we're dealing with what? The Fair Debt Collection Practices Act, okay? The reason why I'm doing this video because there's a lot of individuals that believe that the Fair Debt Collection Practices Act apply to child support. So we're going to see if that information is true or not, okay? So now, let's pick this up at the very top where it states Fair Debt Collection Practices Act. Then it reads background. Then it states the Fair Debt Collection Practices Act, the FDCPA, 15 U.S.C. 1692, which became effective in March 1978, was designed to eliminate abusive, deceptive, and unfair debt collection practices. It also protects reputable debt collectors from unfair competition and encourages consistent state actions to protect consumers from abusive in debt collections. So again, guys, the the Fair Debt Collection Practices Act is simply there to protect consumers, okay? So we need to find out what a consumer is to see if child support falls underneath that term, okay? So now let's go to the Black Law Dictionary to see the definition for consumer. Without further ado, let's go there. Okay, as you all can see, we are in fact again coming from the Black Law Dictionary. Let's pick this up at the very top where it's highlighted in yellow and it states consumer. And it reads, one who consumes. Then it states individuals who what? Purchase, use, maintain, and dispose of products and services, okay? So let's look up the definition for the term product to see if child support falls underneath that term for products, okay? We know that child support in fact offers a service, but in order to be a consumer there must be products and services, okay? So now let's go to the definition for the term products to see if child support fits underneath that term. Let's go there. Alright, so again, as you all can see, we're still at the Black Law Dictionary. Let's read it at the very top, highlighted in yellow where it states product. And it reads, with reference to property, terms refers to proceeds, yield, income, receipts, returns. Okay, so when that's pertaining to property, okay? But let's continue on. It states goods produced or manufactured, okay? So what are the goods that was produced or manufactured from the Child Support Enforcement Agency? Nothing, right? Okay, cool. Let's continue on though. It states either by natural means, by hand, or with tools, machinery, chemicals, or the like. Something produced by physical labor or intellectual effort, or something produced naturally or as a result of natural process as by generations or growth. So again, guys, this is all dealing with what? Goods and services, okay? Basically, produce and stuff like that. Things that are manufactured, stuff that you can go out and purchase and buy, okay? That's basically what a product is, okay? So now let's go back and read consumer so we can finish that definition out so we can get more understanding of whether or not child support falls underneath the term consumer. Let's go there. All right, as you all can see, we're right back at consumer. Let's read it one more time. It reads, consumer, one who consumes. Individuals who purchase, use, maintain, and dispose of products and services. That's all the consumer basically is, okay? One who disposes of what? Products and services. All right? So we know that they're dealing with what? Things that are created, you know, such as things that you can go out to the store and buy. You know, either they're agricultural goods or they're just regular manufactured goods, you know, goods that was created by hand or goods that was grown out of the ground. All types of goods, right? And when it speaks of services, they're talking about the person that's helping you receive the products for the products that you are consuming as a consumer, such as when you go to the bank, right? You go to the bank, you get a loan. You're going to either get a loan for what? A mortgage, car note, credit card or any other type of loan in order for you to do what? Pay off or to purchase some form of product. That's what a consumer is. One who, basically consumes. That's it. They keep purchasing things such as goods and services. But let's continue reading to further prove that. Then it states users of the final product. So basically, what a consumer is, the user of the final product. So let's say I created 20 affidavits. If I created 20 affidavits and someone bought those affidavits from me, that person now became what? A consumer. Why? Because it purchased something that was produced and created. Okay? Let's continue on. Then it states, a member of that broad class of people who are affected by pricing policies, financing practices, quality of goods and services. Okay? So again, it's all a consumer is one that what? Basically produces or goes out and buys goods and services. That's all it is. They buy products such as goods and services. That's it. That's all, guys. To further prove that, now let's go to the definition for goods and services to see if child support falls underneath that term, goods and services. Let's go there. So now let's scroll down to the term goods. I was searching for the term goods and services, but that term is not in the statute, guys. Okay? Because goods means one thing and the legislator used the term service for basically everything. And I'm going to prove that as well. We got more understanding to get to. So let's follow me, guys. Let's continue on. It reads, highlighted in yellow, goods. And it states, a term of variable content and meaning. It may include every species of personal property, or it may be given a very restricted meaning. Items of merchandise, supplies, raw materials, or finished goods. Sometimes the meaning of goods is extended to include all tangible items, as in the phrase goods and services. Okay, so basically goods are nothing but what? Tangible things that's mentioned above, such as, services, like stuff that you can buy. Those are goods. Okay, you buy goods. All right, such as canned goods. You have automobile, you have your house. All those are considered goods, which is also considered to be a form of property. Okay, so now to further prove that, let's go and get more understanding so I can show you guys that the term goods and services are not in the statutes and codes. But let's go to the breakdown of what goods and services mean. Let's go there. All right, so now as you all can see on the screen, we are in fact coming from Cornell Law School, which is in fact one of my favorite websites because their statutes and codes are always up to date. Okay, so now let's come out of the Codes of Federal Regulations, which is 29 CFR subsection 779.314, goods and services defined. So this is in fact the definitions according to the Codes of Federal Regulations. Okay, and it reads, the term goods is defined in section 3I of the act and has been discussed above in subsection 779.14. Excuse me, guys. Then it states, the act, however, does not define the term services. Then it reads, the term services, therefore, must be given a meaning consistent with its usage in ordinary speech, with the context in which it appears, and with the legislative history of the exemption as it explains the scope. Then it states the purposes and the objectives of the exemptions. Then it reads, although in a very general sense, every business might be said to perform a service, it is clear from the context and the legislative history that all business establishments are not making sales of services of some type contemplated in the act. So they basically state that every business does a service, right? But not all business sells a service. Okay, let's continue on though. Then it states, that is, services rendered by establishment which are traditionally regarded as local retail services, establishments such as restaurants, hotels, barbershops, repair shops, etc. Right? Then it states, it is to these later services only that the term service refers to. Okay, so now as you all can see, the term child support enforcement agency is not on there at all. Why? Because the child support enforcement agency is not giving out goods and services. Okay, so because child support enforcement agency is not giving out goods and services, the Fair Debt Collection Practices Act does not apply to this, guys. To further prove that, let's continue. Okay, so now as you all can see, we are in fact coming from Battier.com. I want to go over this case law on the screen that is titled Battier versus Child Support Services Inc., which would be more proof that the Fair Debt Collection Practices Act does not apply to child support cases, okay? Despite what other individuals are telling you guys or want you all to believe, that is not true, guys. Like I've told you all my videos are all facts, all truth, all proof. Nothing more, nothing less. So now let's finish putting this thing to bed, okay? So now, again, the title of this case is called Battier versus Child Support Services, Inc., okay? This is in fact a United States District Court of the Northern District of Illinois case, okay? So this is in fact a federal case. All right. So for all those who are telling you guys to run in the federal court with these types of claims, they are all losing. And this is more proof of that as well, guys. So now let's continue to read. This is in fact a memorandum, opinion, and order. Then it reads, Plaintiff Richard Battier brings this 2-count action alleging violations of the Fair Debt Collection Practices Act and intentional infliction of emotional distress. Then it states, presently before the court is defendant Child Support Services, Inc.'s motion to dismiss the complaint. For the reasons set forth below, defendant's motion to dismiss count 1 is granted and count 2 is remanded to the Circuit Court of DuPage County. So again, guys, the federal court addressed the federal issue pertaining to the Fair Debt Collection Practices Act, okay? And the people that are telling you that child support falls under the Fair Debt Collection Practices Act are the ones telling you all to run in the federal court. Okay, so the moment you go to federal court, you all will receive the same results as Battier, the same results that he received. To further prove that, let's read it. 1. Background. It states, defendant Child Support Services, Inc., CSSI, is a debt collection agency incorporated in the state of Illinois. In December 1993, CSSI sent plaintiff Richard Battier a letter informing him that he owes $17,180. Apparently for overdue child support payments. Okay, so let me stop right there. As you all can see, the Child Support Services, Inc., that is not the Child Support Services Enforcement Agency, okay? The Child Support Enforcement Agency is in fact the arm of the state, which is the agency of the state. The Child Support Enforcement, Inc. is in fact a third-party business that's in contract with the Child Support Enforcement Agency to collect on behalf of the agency, which is arm of the state, okay? Let's continue reading, though. Then it states, right here so you all can see where I'm at, then it states, Battier alleges that CSSI subsequently contacted him several times by telephone and both harassed him and threatened legal actions. Battier filed the present action in the Circuit Court of DuPage County, alleging violations of the Fair Debt Collection Practices Act, 15 U.S.C. subsection 1692, and a state law claim of intentional inflictions of emotional distress. CSSI removed the case to this court and filed the present motion to dismiss. So again, the Child Support Enforcement, the Child Support Services, Inc. moved the case to federal court. Why? Because Child Support Services, Inc. know that the federal Fair Debt Collection Practices Act does not apply to child support, okay? And to further prove that, let's continue reading. And it reads, number 2, motion to dismiss standards. Then it reads, a motion to dismiss should not be granted unless it appears beyond doubt that the plaintiff can prove no set of facts in support of his claims which would entitle him to relief. Case law to support that. Then it further reads, we take the well pleaded allegations of the complaint as true and view them as well as reasonable inferences therefrom in light most favorable to the plaintiff. Another case law to support that. So whenever you file a federal lawsuit in federal court, the federal courts always construe your complaint most favorable to the person that's bringing the complaint. That's in all federal cases, okay? But let's continue on. Number 3, the discussion. Then it reads, the Fair Debt Collection Practices Act, the FDCAP, was enacted in 1977 to eliminate abusive debt collection practices by debt collectors. Insignificant part because existing laws and procedures for redressing these injuries were inadequate to protect consumers. Again, due to that term, consumers. So the whole thing is to protect consumers. Consumers are what? Let's continue reading. We already went over what a consumer is, right? Right, but let's continue reading. Then it reads, 15 U.S.C. subsection 1962 E and B. It states, its scope, however, is limited. The acts define debt as follows. Remember, that's why I say it defines debt as follows, because it don't define goods and services. But let's continue on. It states, an obligation or alleged obligation of a consumer to pay money arising out of a transaction in which the money, property, insurance, or services which are subject to the transaction are primarily for personal, family, and household purposes. Okay? That's what it's for. Household purposes. For what? Whatever is being bought, such as a TV, an automobile, a home. All those are considered to be what? Consumer goods. But let's continue on. It states 15 U.S.C. subsection 1692A5. It is therefore necessary that the plaintiff allege and prove both that he acted as a consumer and incurring the alleged obligation. So, according to 15 U.S.C. subsection 1692A5, if you're claiming that child support falls under the Debt Collection Practices Act, now you have to prove that you was in fact a consumer, meaning that you had actually purchased something from the Child Support Enforcement Agency, which you all didn't. And because you didn't purchase anything from the Child Support Enforcement Agency, you are not a consumer, so you do not fall under the Debt Collection Practices Act. And it's just that simple. To further prove that, let's continue reading. We right here. Then it states, and that the alleged obligation arose out of a transaction in order to fall within the within the ambit of the Act. Although there are few reported cases addressing this portion of the Act, their discussions of the section requirements is instructive. For example, in Zimmerman versus HBO, the court noted that the Fair Debt Collection Practices Act was enacted as an amendment to the Consumer Credit Protection Act, 15 U.S.C. 1601, and concluded that the type of transaction which give rise to a debt, as defined in the FDCAP, is the same type of transaction as is dealt with in all other subchapters of the Consumer Credit Protection Act. So again, guys, nothing changed. Everything is still the same. Basically stating that the Consumer Credit Protection Act and the Fair Debt Collection Practices Act are all referring to the same consumers, okay? But let's continue on. I.e., one involving, let me show you where we at, i.e., one involving the offer or extension of credit to a consumer. So your question is, what offer of credit did they offer you as a consumer? They never offer you any credit, guys. They don't offer us credit. They're not giving us loans. Okay, so because they're not giving us loans, you do not fall underneath the Consumer Act. Okay, they do not fall under the Fair Debt Collection Practices Act or the Consumer Credit Protections Act, guys. But let's continue on. Then it states, where was I at? Okay, right here. It states money, property, insurance, and services which are primary for household purposes and to defer payment. So basically, it's the deferred payment on what? Household services such as homes, cars, credit cards, all that type of stuff. To do what? To purchase goods and services. That's all it is, guys. But let's continue on. Case law to support that as well. Then it states right here, concluding that the Fair Debt Collection Practices Act applies only to what? Consumer debts. Okay? Child support is not a consumer debt. Child support is a common commercial, common civil debt. Different things, guys. So don't be fooled. But let's continue on. It states, and considering the purpose for which the credit was extended in order to determine the nature of the debt, quotations omitted, right? Then it states right here, it states the Fair Debt Collection Practices Act intended to apply only to debts contracted by consumers for personal, family, and household purposes, guys. Okay, this has nothing to do with child support. You come to court trying to argue this stuff for child support and you will lose. Okay? I'm just telling you guys the truth. Take it how you want it. But the truth is the truth, and the truth shall what? Set you free. First you have to, receive the truth in order to be free. A lot of you guys don't want to receive the truth. You guys want to be fed lies all day long. You want to be lied to. You want to hear good things instead of the right things. You want to hear the truth. Let's continue on, though. Then it states, relying upon these cases, the Fourth Circuit recently rejected a claim identical to the one advanced by the plaintiff in the present case. In Maybe versus GC Services Ltd partnership, the plaintiff had allegedly failed to pay their respective child support obligations. The defendant entered into a contract to collect those payments on behalf of the Commonwealth of Virginia. Same thing in this case in the state of Illinois. The CSSI entered into a contract with the Child Support Enforcement Agency for the state of Illinois, and now, they're coming after this individual known as Battier to receive payment from that individual, right? But he got mad and ran the federal. First, he filed a claim in state court against the CSSI. The state CSSI moved it from state court to federal court because he's addressing the Federal Debt Collection Practices Act, and it's just that simple. But let's continue on. It states, which have been assigned the rights to receive the payments by the plaintiff families. Then it states, which were instead receiving welfare benefits from the state. Then it states, the plaintiff objected to the actions taken by defendant and filed a lawsuit alleging violations of the Fair Debt Collection Practices Act. Then it states, the district court dismissed the complaint, holding that the obligation to pay child support is not a what? It's not a debt. Why? Within the meaning of the act. Why is not a debt within the meaning of the act? Because they're talking about actually purchasing some form of goods. Child support is not giving you guys goods and services. They're only providing a service on behalf of what? The state to collect what? A legal obligation and or duty. That's it. That's all, guys. All my videos, I say the same thing. I never change my pitch. Go back to my very first videos, guys. I've been telling you guys this for 6, almost 7 years now. This truth. But let's continue on. Then it states, on appeal, the Fourth Circuit affirmed, right? It states, in the instant case, the appellant's child support obligation arose out of an administrative support order issued by Virginia's Department of Social Services, DSS. Then it states, these obligations, therefore, do not qualify as a debt under the FDCPA. Again, okay? Then it states, because they were not incurred to receive consumer goods or services. You see? Why? Because they was not received as what? Consumer goods or services. That's why you cannot take these types of claims in any court, state or federal court, when you're talking about the Fair Debt Collection Practices Act. That's it, guys. But let's continue reading. We almost done. Then it states, rather, the DSS imposed these obligations upon appellants to force them to fulfill their what? Parental duties to support their children, guys. I keep telling you guys, it's a legal duty, also known as a legal obligation that they're placing on us men to get us men to perform the way they want us to perform. But let's continue on. We see no reason, right here, so you all can see where I'm at, very top line, right here. We see no reason to defer with the Fourth Circuit's well-reasoned conclusion. Battier's child support obligations were not incurred as a consumer, nor do they arise out of a transaction in which Battier obtained credit in order to pay for personal goods and services. So again, guys, when people are telling you that child support is in fact a loan, child support is not a loan, guys. Child support is simply a service that your child's mom went down and applied for. That's it. That's all. But let's continue on. Then it states, instead, his obligation to support his children exists simply because his children exist. Battier's obligation to fulfill his parental duties, therefore, does not constitute a debt within the meaning of what, guys? The FDCPA. And it's just that simple, guys. So, again, this is what the federal court is ruling. I'm not making this up. This is not my document. Okay, this is what the federal courts are ruling. So if you guys are thinking of bringing these arguments in federal court, you will receive this same outcome as Battier. If you don't believe me, try it out for yourself and let me know the outcome. It's just that simple. But let's continue on. And as a result, CSSI, right here, so y'all can see where I'm at. And as a result, CSSI is not subject to its proscriptions in this case. Accordingly, we dismiss count 1 of Battier's complaint. And as we have dismissed the sole federal claim present in Battier's complaint, we decline to exercise jurisdiction over the remaining claim pursuant to 28 U.S.C. subsection 1367C, and instead remand the case to the Circuit Court of DuPage County. Number 4, conclusion. For the reasons set forth above, count 1 of the complaint is dismissed, and count 2 is remanded to the Circuit Court of DuPage County. It is so ordered. So again, guys, child support is not a debt that falls underneath the FDCPA. Do not be deceived, guys. Do not let anyone tell you all these lies out here. That's why they can't show proof of them winning their own cases, guys. Okay, it's a lot of scamming and a lot of, it's a lot of fraudulent and just misinformation going on, guys. You all must distinguish which is true, the truth from the lies. Like I tell you all of my videos are factual and truth. There's no rebutting nothing I put up, okay? Why? Because I'm breaking it down to you guys to the lowest common denominator, to the lowest point that you all can comprehend and understand, okay? So with that being said, guys, that's all I'm going to do for today. If you all need my help, hit me up in my email at y'allismagnified@gmail.com. Let's get this right wisdom, let's get this right knowledge, and this right understanding. With that being said, guys, you all be blessed, and I say shalom.